Okay, what's going on? I'm Marcus. Here we do attorney reactions. Now we're going to revisit the track high school athletes who someone got hit. It was a question of if it was accidental or intentional. I actually did a video where I broke down where we looked at footage from the front end of the incident and from the back end, and I gave my point of view and perspective. Long story short is, hey, it looked intentional initially when we viewed it from the front and listened to the first explanation from the perspective of the victim in this case. Then when we actually looked at, or when I actually looked at the footage from behind, and heard the explanation of facts as described by the defendant in this case, it seemed plausible. Now, I know a lot of people in the comments were like, no, it's intentional. I ran track for 6 years, or my daughter ran track for 6 years. Well, quiet as it kept, a jury isn't going to be made of all track stars. That's just what it is. The fact that this is a question that's posed over the internet, like the whole little dress thing, is it a gold dress? Is it a blue dress? Because so many people are so torn, it's a reasonable doubt. So there isn't enough. Me personally, if I were a prosecutor in that district, I wouldn't touch this case because I just don't think that there's enough there to say that this was intentional. I don't think it's enough there to say that this was criminal intent beyond a reasonable doubt. Someone in the comments even said, hey, I looked it up. The victim in this case was like the number 2 runner in the state or something. And the girl who hit her was terrible. She wasn't even ranked and she was jealous. And that same argument that she just made, that person who left that comment made, saying why it was intentional, the exact same argument would be used to show that it wasn't intentional. Why would she be jealous of this lady of this girl who is ranked number 2? The defendant, my client, lost a bunch of races. She's not even nationally ranked. Had she taken all of these L's, she's never behaved like this before. She's never been jealous of someone who beat her, and she got her ass whooped a lot because she's not a superstar in track. She's never struck an opponent who beat her in a race or was on the verge of beating her. That actually goes towards potentially proving that it was accidental as opposed to intentional. So the fact that it's down the middle like that, some people say yay, some people say nay. When in doubt, when there's any mild benefit, it goes in favor of the defendant. Now the prosecutor has chimed in. Let's take a look at this video, then we're going to break it down because we talked about accidental and intentional, but I didn't break it down in a solo video like this of what is actually going to happen. Let's dive in. Let's see what's going on. Let's get it.
Alayla Everett has been charged with the misdemeanor of assault and battery out of Lynchburg. Now, I spoke with Everett's father, who told me his family is going to fight this to help clear their daughter's name. The Lynchburg Commonwealth's attorney confirmed on Wednesday that Everett was charged for her role in the incident in Lynchburg, where she is seen hitting another runner, Kaylin Tucker, in the head with a baton. Earlier this week, I spoke with Everett and her dad. She said what is seen in the video was an accident. Everett said she lost her balance because the runner did not provide herself enough distance to cut into the inside lane of the track during the race. Everett says the hit was not intentional, but she's received backlash online, including death threats. We spoke to Lynchburg Commonwealth's.
Okay, so death threats is wild. People, let's put this in perspective. These are 2 high school students. From everything I can see from open source, neither one of them has any prior contact with the criminal justice system, which is going to be paramount in how this is going to play out. Now, I think I know how it's going to play out. I don't agree with how it's going to play out, but I think I know what's going to be offered. I can't speak for if they're going to accept it. Maybe a little ego gets involved. Let's finish up.
Attorney Bethany Harrison, who explained the outcome for Everett if she's found guilty in juvenile court.
The court has many what we call dispositional options available to it, many things the court can order to help in that goal of rehabilitation. It could be community service, it could be time in detention, and a lot of things in between, like counseling, services of that nature.
The Portsmouth NAACP is reacting to the charge. I'll tell you what they had to say at 5. I'm Danielle Seda, WTKR News 3.
Okay, now this is interesting. Real quick, let me see what the NAACP said. I can guess. I think I know what they had to say. Trust me. Let's see if we can find it. Whatever. Can't find it right now, so we'll figure it out on the back end. Now, this is essentially what's going to happen. We got to understand a little bit about the Virginia state court system. They have a lower level court that is a system, a system where the trial judge is the trier of fact. What does that mean? And a lot of states have this. If you're charged with a misdemeanor and you go in front of a judge and you want a trial, you don't get a jury. The judge is your jury. Now, if you lose and you appeal it, on appeal, you actually get a jury trial. Now, I know y'all probably thinking, DFD, that sounds unconstitutional. I deserve to be heard in front of a jury of my peers. Yes, that's true, but the Supreme Court had actually ruled on this a long time ago. As long as the person has a jury process throughout the entire life of the issue of the litigation, there's no constitutional violation. So in Virginia, this is a misdemeanor. It'll be heard in front of a judge. The judge will make a determination of guilt and innocence. Now, what's good and bad about that? Honestly, the only thing good about it is it makes the process move faster. I think it's generally all bad. I can count, I've probably had 20, at least 20, maybe 30 cases where we had a trial at the lower court. The judge found the client guilty. We appealed it, and in front of a jury of 12, the person was found not guilty. It happens all the time. Judges are persons. A judge will sit on the bench and be like, my grandson ran track, so I know how it goes. Like, judges think they've heard it all, seen it all, and done it all. So, what will likely happen in this situation if the defendant has no prior contact with the criminal justice system? One, she'd likely be offered or potentially be offered a deferred prosecution. What is a deferred prosecution? Long story short, the court and the district attorney will agree to hold off on even prosecuting and pursuing that charge. They'll say, hey, if you do 50 hours of community service and anger management and stay out of trouble for 3 months, we'll continue this case for 3 months out. And when you come back, if you comply with all of those provisions, we'll dismiss this charge. Once the charge is dismissed, then the defendant can actually get it expunged and moved from a record, and she can go on about her life. Here's one of the things that's kind of bad about that, and I'm not really a fan of. I understand it in some circumstances, but we'll talk about it. A lot of times, in exchange for a deferred prosecution, the state would make the defendant sign a letter essentially admitting to guilt. Now, is that a big hurdle to overcome? No. I've had clients who took a deferred prosecution. They didn't comply with the terms. We went to trial. At trial, the DA introduced the letter that they signed saying they admitted to responsibility. And the client was like, I wasn't admitting to responsibility. I just was trying to get this resolved, but I, in fact, didn't do it. And we walked out with a not guilty verdict. So just know if there's a deferred prosecution, they may make her sign a document admitting responsibility. If she doesn't comply, then they'll introduce that document as evidence in her trial if it actually goes to trial. Now, here is unique. I think this is a split issue. I think 60% of the internet says it was intent. I think 40% said it was accidental. With that, if there's even 1% that says it's accidental, that's a reasonable doubt. So I don't think there's enough to actually win a trial in front of a jury. In front of a judge, it's a toss up. Now, what should the defendant do? Generally, if you have a method to get a guaranteed dismissal, you should take it. If they offer you a deferred prosecution, you should take it. I have had clients who were like, no, I'm not doing no community service because I didn't do this. You can stand on business if you want, but I always told my clients, take the deferred prosecution. If you fail to comply with the terms and we have to go back to trial, we'll deal with it at that point in time. That's probably the advice I would give. But if the ego comes into play, I don't want to do community service if I didn't do it, we'll see how that plays out. Now, I'm not a fan of the prosecution offering a deferred prosecution, even though if it's offered and I were the defense attorney, I would advise my client to take it. Here's why I'm not a fan. If I was a prosecutor, I'm basing my case on if there is evidence to prove that the person had the criminal intent to do it, and can we prove this beyond a reasonable doubt? Here, I think the evidence shows there's some doubt. I think if you lined up 10 people and asked them if it was intentional or an accident, I think 6 will say it was intentional, 4 will say it was an accident. I can't meet my burden. I think it's piss poor prosecution. If I feel like I can't meet the burden of proof, I'm not going to waste the defendant's time offering them a deferred prosecution. I only offer deferred prosecutions to people I knew, hey, the evidence proves that you're guilty beyond a reasonable doubt, but you don't have any prior record. We're going to give you this chance to keep your record clean. A deferred prosecution is not meant to say the evidence proves that you may or may not have the intent to do it, but we're going to offer you this deferred prosecution and just let you get a dismissal. And if you don't do it, we're going to try to prosecute on the thing that you may or may not have had intent to do. I think that's prosecutorial misconduct, but it happens all the time. So that's how this is going to play out. You all let me know what you think in the comments. I'll link the video where we went through the accidental or intentional analysis. Y'all let me know what y'all think in the comments. Again, was it accidental? Was it intentional? And if you were the defendant in this case, would you take the deferred prosecution even though the facts are somewhat favorable? The intent element is a legitimate issue. Y'all let me know what y'all think in the comments. And if you enjoyed this content, check out the content on the screen. There's going to be more content related to attorney reactions.